defend the Constitution and the laws of the Republic of Namibia to the best of my ability. Welcome back. It is almost becoming a tradition whenever we have the national budget before the House or the midterm budget review, we normally have a discussion facilitating comments and observation from parliamentarians, experts, and the rest. In keeping with that tradition, the National Assembly, in partnership with the Federal Herbert Stiftung, is inviting members to attend such a visual session on assessment of the 2020-21 national budget. Ready? Even here. Okay. I know the technicians are hearing me as I'm waving at them. Can they do something about it? Is it coming through now? In fact, they were here before the session to double check the system. Are you hearing me? They are busy. They are busy trying to sort it out. Are you? Could you signal once you are on top of the game? I will. Can Okay. Can you hear me now? I'm sure you can hear me now. We are back in business. As I was saying, the National Assembly, in partnership with Federal Herbert Stiftung, is hosting a blended visual session on assessment of the 2020-21 National Budget Midterm Review, 2020-21 Appropriation Amendment Bill. Now, this event is taking place tomorrow. Monday, at the Havani Hotel, and members are requested to kindly confirm your attendance so that we take that into account. So that is for your information. Any petitions, reports of standing select committees, other reports and papers? Minister of Finance.
Honorable Speaker, I lay upon the table reports of the original accounts of the Ministry of Health and Social Services for the financial year ending 31st of March 2019. Another one for the Ministry of Finance for the same financial year, 31st of March 2019. Third, for the National Planning Commission for the financial year, the same financial year, 31st of March 2019. And further for the National Council for the same financial year. And lastly, for the Village Council of Itivundu for the financial year ending 30th of June 2019. So I so move, Honorable Speaker.
Thank you. Let's move on. Notices of questions. Honorable Ganani.
I crave for your indulgence to ask an oral question under Rule 91 of the Standing Rules and Orders to the Minister or Deputy Minister of Home Affairs, Immigration, Security, Police, and all those matters that matters.
Can I have the gist of the question?
Honorable Speaker, through you, it was reported by the Prosecutor General, who was ashamed that a particular person who is believed to have stolen 25.7 million from August 26, who was fired because of the malfeasant behavior. The Prosecutor General raised a question in the public media saying that she was surprised that the police has not arrested this particular person. Now, given the necessary caveat of names of people that are only accused, I want to know from this government, through you, Minister, when are you going to arrest the alleged people that have stolen 25 million? Because when it comes to stealing, this government behaves very patriotic to those that are stealing and robbing this country. So how is it possible that somebody who is accused of having stolen so much money has not even been arrested and has not even appeared in a competent court of law? This is how you are selling this country.
Are you in a position
for money.
respond to such a question? Honourable Member, the question is being responded to. Deputy Minister, you have the floor.
Thank you very much, Comrade Speaker. I think the question asked by Honorable Venani might be relevant. However, I would rather request the Honorable Member to put that one in writing so that we can have a proper answer to that one.
Thank you very much. Honourable Sepep. Honourable Sepep. Honourable Sepep.
Yeah. No, Speaker, this one is directed to you. I asked a question was it last week, Tuesday? And then I saw somebody was trying to talk some lies and some other things here in response. I read today, what is that mean? Omar Bensa. Yeah. Now and then he tried to respond. I don't know whether it's a ministerial statement.
Let me help
Honorable
you.
Mike Kavekotura was
Let me
trying
help
to
you.
guide you.
Let me help
And
you.
then now, I want the answer. I'm here.
Let me help you.
Why are people scared of
Let
me
me-
coming and answering me here?
Let me help you.
Yes, Honorable Mutorwa.
No.
The person
no,
answered.
No,
You
no.
can't say it like this.
Honourable
I
Member.
asked an honest question.
Honourable
and
Member.
I demanded an answer. But
Honourable
now,
Member.
the
Honourable
person,
Member.
I don't know whether you granted him
No,
permission
no.
to answer and talk all the things that he was talking about.
Let me help you.
Yes.
Let me help you.
All right.
Okay.
Yes,
The
I can make noise. It's parliament. Why are these people crazy?
No. Honorable member,
Yes, Utoni.
no.
Yes, I
Honourable
will
member,
insult Utoni. You want to be insulted?
Honorable member,
Huh? I can
Honor-
deal with you. There is no
Honourable
break here.
member.
Go and eat food outside.
Honorable member,
Yes.
you put the question to the speaker.
Yes.
I'm
No,
responding.
but Utoni is interfering.
No,
Why
no.
don't, are you scared of kicking out Utoni from here? Huh?
You are directing the
Yes.
question to
Are
me.
you scared of Utoni? Please. Yes, you can answer.
Okay.
Proceed.
Okay.
Yes.
The answer will come to that. I'm going to ask you to put the question, and the question is going to be responded to. The question is going to be responded to. Today. No. Yeah. Then let me clarify. Let me clarify the position. The position. Last Thursday, I was not in the House. There was an understanding between the Honorable Minister and the Deputy Speaker who was presiding that in view of the fact that the Minister was going to be absent, could he respond by the ministerial statement? Now, no, let me finish. Then, that understanding that you, if you were in the House, then it would be with your consensus that would be done. Since you are not in the House, it will remain on the order paper. When we get there, I will ask you to put the question, and the question will be responded to.
Now, but if the minister wants to why didn't he speak already and let the
No, we will get there. No, it is, the rules are very clear. No, the rules are very clear. You could do that. As I was saying, I was not in the chair, but, so we'll deal with that. We'll deal with that. Okay. Honorable Kavegotora? Yes.
Yeah, thank you very much, Honorable Speaker. I don't want to say I told you so.
No,
But,
no.
I want to...
We dealt with the issue.
Speaker, you cannot say no. I
We
was
dealt with the
trying
issue.
to help you, but you were simply not wanting to.
No.
But it's fine. I told you so. Honorable Speaker, I want to pose two very urgent oral questions. One to the Honorable Speaker, and the other one to the Honorable Minister of Information and Communication Technology.
Let's hear the question.
The one is a very basic one, Honorable Speaker. We are approaching elections. And we know that we're not going to use the products that brought us here, the EVMs. Obviously, we're going to use, according to ECN, we're going to use ballot papers. My question is basically very simple. Who is going to print those ballot papers? Because that is a very critical question to me. Being a victim of the 2009 election that were rigged by SWAPO, I really need to know who's going to do the printing of. Yes, you rigged the election. That's a fact. You know that, and you know that I know that there were foreign books that were used in those elections. You know that.
Okay.
I can even name names of people who did that.
Please.
So,
I got the clear question.
I want
second question.
that is what I want to know. Number
I
one.
got it.
The second very important oral question, Honorable Speaker. RDP is going to participate in this coming election. Now, Honorable Mutora, you must understand why I'm alone here. It's because of the EVMs, and you know that. You know that. We can.
No.
Look at Utoni. Utoni, there you go again. It's about two things.
Order.
It's about the fish rot money, and it's about the EVMs. That you know. But let me come to the point. Honorable Speaker, our participation in this election, we come to the surprise that the rigging has started already from them. We have fielded a candidate in the Mukwe constituency. Just listen. We have fielded candidate in the Mukwe constituency. Mutora, please listen, Honorable. Now, the returning officer gave that information to NBC through Kavango Radio. NBC deliberately chose to not mention the participation of RDP in the Mukwe constituency. They only went for SWAPO and all the other people, but RDP was deliberately excluded. I want to find out from the Honorable Minister, why are we being excluded, number one? Who did that deliberate act? And what is the minister going to do about that deliberate act of basically trying to sideline RDP, a political party that has been registered in this country under the laws of this country? I just need to know that, because this rigging that started since independence,
let's get the answer,
will have to come to an end. So I need those questions, I need those answers, Honorable Speaker, please.
Thank you very much.
And it's very urgent.
Thank you very much.
Because our people are calling, they are calling to say, but when did we decide not to participate in this election?
Okay, thank you very much.
So the SWAPO rigging must just stop.
Thank you very much.
Must come to an end.
Thank you very much. Honorable Minister, is the Minister in the House? Minister of Information and Communication? He's not. The Deputy Minister? Okay. The Minister or the Deputy Minister are not in the House. So can we... No. Please. Both the Deputy Minister and Deputy Minister are not in the House. Can we leave it at that?
Engage them.
Yes.
In a different platform.
Thank you. Thank you very much. Now, with regard to the question directed to me, obviously, you will not expect me to be in a position to know the technical logistics, ballot papers, where they're going to be printed. This is something I have to investigate and find the proper responses. Thank you very much. We move on. Notice of motions, messages from the President, ministerial statements. So we commence with the questions. The first question number 36, is from the Honorable Van der Heever. Do you put the question? Directed to the Minister of Public Enterprises. Minister, you have the floor.
Thank you, Honourable Speaker. So I'm happy to answer the question and that the Honourable Member is in the House today. So, from the Speaker, I can confirm that AgriBizDev has been classified as a commercial public enterprise, and that the Ministry of Public Enterprises plays a conduit role as a shareholder ministry in the release and processing to the company of funds appropriated by Parliament for the operations of AgriBizDev, including personnel expenditure. It should be noted that all money transactions are done in line with the provisions of the State Finance Act and procedures. As to how long that will be the case, I wish to state that the commercial public enterprises are all expected to run their affairs in a commercial manner and be self-sustainable, thereby relieving the state from their reliance on Treasury. The reforms that the Ministry is undertaking aim to position these public enterprises to be self-sustaining It is a process, but our assessment is that with the right business model and an appropriate governance and management structure, agribusiness has the potential and capacity to achieve commercial sustainability within a relatively short period of time, save for the ongoing impact of the COVID-19 pandemic, of course. The second question, I can confirm that the suspension of, and with respect, the late agribusiness managing director was for 3 months, and therefore the investigation was to be concluded within that same period. However, due to unforeseen delay in concluding the procurement process, as well as the problems with the lockdown under the COVID-19 restrictions, it was mutually agreed to extend the investigation period by an additional 2 months. The timelines were further impacted by the required travels to the project sites by the investigation team, as well as the sudden death of the suspended managing director. And this report is now expected to be submitted to the ministry by November 2020. The third question, Honourable van der Heever's concern is fully shared, and I do agree that suspensions are costly. Suspension of CEOs or managing directors or other senior executives of public enterprises are one of the things that I do not condone and where practically possible wish to minimize. In the case of agribusiness, several serious allegations have been made about this entity, while on the other hand there was evident proof of a weak balance sheet, high debt and overall poor performance. This situation compels the need for an independent audit investigation and to ensure an unhindered investigation and the integrity of the process. The MD was excused from office for a limited period of time. With regard to national food security, it is correct that agribusiness should play a pivotal role and should be positioned to deliver optimally on its mandate. We are currently in discussions with the Ministry of Agriculture, Water and Land Reform to consider an alternative approach and a new business model to unlock the vast opportunities under agribusiness and to optimize those opportunities as a matter of priority as soon as practical. And I thank the Honourable Speaker.
Thank you very much. Thanks a lot. We move on. The Honourable Malema, you put the question. Thank you very much. The question is directed to the Minister of Industrialization and Trade. Minister, you have the floor.
Thank you, Honourable Speaker, Honourable Members. Let me first thank the Honourable Member for putting the question on the progress on our trade policy, which the Honourable Member became aware of through our consultations that were held in the regions. Where we are with the policy, we are still waiting for written submissions as committed to by the regions, including a region where the Honourable Member participated. I am told he is part of those that have committed to submit a written submission, which is not received as yet. And also, due to the limitations on public gathering by the regulations on COVID, we are left with one region in terms of consultation, which is Karas region, which we will duly consult in the next few days. When will the policy put into effective use? That will be done when that process is completed. And we are urging those regions and the participants that have committed to submit written submission which are outstanding. So far, we have only received written submissions from Oshana, Kavango East, Kunene, and Omaheke, with about 4 or 5 regions pending who committed to submit written submissions. Once the submissions are received, they are reviewed. What is relevant then is incorporated in the draft policy, which will eventually come to this August House after it have gone to Cabinet. And it can only then be put into effective use once that process is completed. I therefore want to inform the Honourable House and the Honourable Member that the policy will still come here for our inputs and our submissions before it's eventually be launched for public use. I thank you.
Thank you very much, Honorable Member. Tako, thank you very much. We move on. Question number 38 is from the Honorable Kivumbu, directed to the Minister of Justice. Do you put a question? Thank you. Minister of Justice.
Thank you, Honourable Speaker, and thank you to the Honourable Member for the very important question about the importance of widely making legal services available to as many people, but also other institutions that may become part of the consideration. So I want to, Honourable Speaker, I will not repeat the question, but I want to respond to the first question as follows. Honourable Speaker, we refer to the above question relating to legal aid representation for small and medium enterprises, or SMEs, for short, which are now also called micro, medium and small enterprises, in the national policy developed by the Ministry of Industrialization, Trade and SME Development in November 2016. I would like to inform this August House that the object of the Legal Aid Act 29 of 1990, as outlined in the preamble, which is to provide for the granting of legal aid in civil and criminal matters to persons whose means are inadequate to enable them to engage practitioners to assist them. End of quote. The regulations made under the Act further outline a number of criteria to determine the eligibility of legal aid, and in sub-regulation 2.1 thereof, it states, and I quote, "A person may qualify for legal aid if his or her monthly income, as determined in accordance with provisions of that particular regulation, does not exceed the amount of 3,500, and that is subject to further provisions of that regulation." Income in this instance means the balance of the applicant's salary or the net income of the applicant after his or her monthly deductions. The further regulations empowers the Director of Legal Aid to use his or her discretion to grant legal aid where the amount of 3,500 mentioned is exceeded by a further amount of 1,000 Namibian dollars, and only if it is in the interest of justice, such an application for the additional amount shall be granted. That said, Honourable Speaker, it should be clear that the regulations made under the Act refers to natural persons who work to earn an income. It is that income that determines the eligibility for legal aid. There is currently no provision in the Legal Aid Act of 1990 that extends the provision of legal aid to MSMEs or to private companies. It is also important to inform this esteemed August House that the reference to a person in Regulation 2 of the regulations made under the Act refers to a natural person and does not include a company or a business entity for purposes of legal aid. We take this view after considering that the Legal Aid Act does not define a person to include a juristic person. If it was the intention of the legislature to include companies or other business entities under the Act, then the word person would have been defined and extended to include juristic persons. Honourable Speaker, we confirm that we do receive applications for legal aid involving companies that are owned by persons who are not able to pay the fees of legal practitioners. As I have previously mentioned, however, applications from companies or other business entities are not considered, as these are not regarded as indigent persons for purposes of the Act. Lastly, beside the criteria in Regulation 2 of the regulations made under the Act, Section 14 of the Legal Aid empowers the High Court or the Supreme Court to issue a legal aid certificate to any party to an appeal that is not legally represented, and if the court is of the opinion that a legal question of public importance is likely to arise in the appeal, then that particular certificate would be considered for purposes of granting legal aid. In respect of the second question, Honorable Speaker, the question is whether or not and should the Ministry of Justice consider extending the scope of legal aid to include companies or other business entities or even commercial transactions, then there may be need to redefine who exactly should be granted legal aid and to establish the threshold that must be put in place to ensure that state resources are directed only to those who are in dire need of legal representation. Currently, the Ministry of Justice is seeking to shift the focus of granting of legal aid only in criminal cases to include civil and other social impact cases such as maintenance, domestic violence, and deceased estates cases. We have already started with this initiative, and we are proud to state that some resources are spent on enabling applicants in these types of cases. Extending the scope to cater for legal persons will require yet another expansion of the establishment and increase in funding for that purpose. However, we take cognizance, Honourable Speaker, Honourable Members, of the challenges of MSMEs and agree, in fact, that it is necessary for government to find a way to assist these entities in a sustainable and affordable manner that will give them security from exploitation. I concur that not all business owners have the knowledge and ability to contest legal claims that are instituted by big and powerful corporations. So this is a matter that I believe has to be addressed in consultation with all stakeholders concerned. In the meantime, Honourable Speaker, we will explore the possibility of the request to provide legal aid to MSMEs who are facing financial difficulties, and we encourage them to visit our Directorate Legal Aid to request for advice on possible actions and support that could be made available in the interim. I'd also like to take this opportunity to inform the House that the regulations made under the Act were reviewed in April 2019, and one of the main reasons for that review was to increase the threshold of eligible applicants to 3,500. This was done to ensure that more people qualify for legal aid. Naturally, this will entail an increase in legal costs, particularly where instructions are outsourced, but we have also an increase in in-house capacity to reduce outsourcing. We've managed over the past 2 years to increase the number of in-house counsel who are now handling the biggest percentage of legal aid cases. For instance, Honourable Speaker, in the financial year of 2019-2020, the Directorate Legal Aid received a total of 10,669 applications. Of these, a total of 7,193 applications were approved or granted, and a total of 2,667 were refused. Of those approved applications, only 1,324 instructions were given to private legal practitioners, which represents about 18% of the total approved applications, while 2,610 instructions were given to legal aid lawyers, which represents about 36% of the total approved applications, leaving a total of 3,349 approved applications still pending. I also take this opportunity to clarify that Article 95H of the Namibian Constitution requires the state to promote and maintain the welfare of the people by adopting, inter alia, policies aimed at the legal system seeking to promote justice on the basis of equal opportunity by providing free legal aid in defined cases with due regard to the resources of the state. Despite the provisions of Article 95H, however, it is important to elaborate the provision of legal aid is not an absolute right, but it depends on the availability of state resources. This is the reason why we now require a contribution of 350 Namibian dollars from every person who's granted legal aid, with the aim of sharing some form of accountability and of responsibility, and to ensure a more equitable allocation of funds between criminal and civil cases. Lastly, Honourable Speaker, I would like to mention that the right to a fair trial under Article 12 of the Namibian Constitution is not dependent on whether the accused has a legal representative or not. The rights of an accused should without doubt be upheld and protected in all cases, and the presiding officer who is in charge of the court proceedings must ensure that the rights of accused are not violated. In respect of the second question, Honourable Speaker, the magistracy has a current approved structure of 104 magistrates with 90 filled positions, 90, and 17 vacancies. However, it is important for this House to be aware that the shortage of magistrates is not the only reason why matters are delayed in court. It is only one of the reasons. The flow of cases in court largely is dependent on stakeholder involvement, as the magistrates are not the only parties to court proceedings. At this stage, every court is attended to by a magistrate on a daily basis, unless circumstances for absence is justified. It is true that there are areas where there are a lack of available magistrates and that the current needs for enabling citizens to access justice is delayed. The Magistrates Commission, as the body charged with the overall responsibility of recruiting magistrates, has realized this need and is currently reviewing the structure of the magistracy, particularly in light of the fact that it was separated from the public service. It now falls squarely under the office of the judiciary. The Magistrates Commission is also reviewing the transformation of business processes at the courts. All of these review exercises are important. All of these review exercises, are influenced by a number of factors, which include the envisaged amendments to Namibia's divorce law, the increase of civil jurisdiction and the criminal case flow management. Also, and although this process is at a consultative stage, which involves a number of experts who are dealing with the structure, grading and regrading, and once finalized and approved by the Magistrates Commission, will be forwarded to the Minister of Justice for consideration and further consultation with the Minister of Finance. The Magistrates Commission expects to finalize these review exercises by the end of March 2021, with the aim of having more magistrates on board during the first quarter of the next financial year, once the administrative and financial approvals are guaranteed. The third question, Honourable Speaker. What is preventing your ministry from appointing acting magistrates? This is an avenue that the Magistrates Commission has never explored. Currently, they have never appointed legal practitioners because the Magistrates Act 3 of 2003 does not make provision for other officers other than magistrates to be appointed in acting capacities. There has never, in the 17 years of the magistracy's existence, been a policy on how acting appointments ought to be done. Currently, when a regional court magistrate or any magistrate vacates office, the divisional magistrate decides who must be appointed by the Magistrates Commission in such a capacity. There are no designated acting positions that were, or advertisements that were sent out, and once that is done, people apply and are appointed after an assessment. There is currently a proposal before the Magistrates Commission in which the issue of acting will be reviewed and regulated. Thank you very much, Honourable Speaker.
Thank you. Thank you very much. We leave it at that. Question number 40 from the Honourable Kazekotora. You put the question. Thank you. The question directed to the Minister of Defence and Veteran Affairs. Minister, you have the floor.
Honorable Speaker, honorable members, I rise to respond to the questions posed by Honorable Mike Adekotora, the RDP. I would like to thank the Minister for putting the questions. Start with question number 1. Question number 1 has to do with the veteran housing program. And the question is, how many houses has the government until now constructed up-to-date constructed for the veteran? Since the inception of the veteran housing program, the Ministry of Defense and Veteran Affairs has constructed 294 houses countrywide for the benefit of the veterans of the national liberation struggle. These houses are distributed across all 14 regions of the country as follows: Erongo 12, Ardap 22, Kara 17, Kavango East 12, Kavango West 15, Koma 17, Kunene 9, Angwena 44, Omaheke 14, Oshana 13, Oshikoto 47, Omsati 45, Dodonjupa 9, Zambezi 18, totaling 294. The second question is, how many houses does the government intend to construct? So far, the ministry has received 203 housing applications for the Veterans Housing Program. These applications are yet to be assessed to come up with a waiting list of those that meet the criteria. However, due to budgetary constraints, which led to the non-allocation of funds to the project for the budget years 2020-2021 to 2022-2023 medium-term expenditure framework period, the Veteran Housing Program is currently on hold until funds are available. In the meantime, the Ministry is also exploring the possibility of interministerial collaboration with the Ministry of Urban and Rural Development in order to cater for some of the veterans that could benefit from their different housing initiatives. Question number 3. There seems to be another group in the same category given government houses on a lease basis. The idea seems to be that these houses will revert back to government once the lessee dies. How fair and equitable is such a system to people who sacrifice their lives and livelihood for this country? Honorable members, Honorable Speaker, Honorable members, all the houses constructed under the Veteran Housing Project are fully donated to the beneficiaries and are inherited by the relatives of the veterans upon their demise. So there are no veterans that qualify for veteran housing programs. And I want to stress that there are no veterans that qualify for veteran housing programs that received houses on a lease basis. However, it should be noted that there is one veteran who, due to special consideration, is currently accommodated in a government house acquired by the Veterans Board. This is so because the member owns a house and therefore does not meet the requirements of the housing program. Furthermore, this house does not form part of the Veterans Housing Program. However, the veteran is given free occupation rights over the property of which he is informed, but it remains the property of the state, and as such, the government is responsible for the rates and taxes, whilst the veteran is responsible for his own water and electricity bills. Question number 4, how does the ministry make that distinction? Of course, as I said before, there is only one such case, and then it was motivated by the unique circumstances under which the veteran finds himself. Question number 5, would it be prudent and justifiable to give the ownership of this property to the lessee? Honorable Speaker, honorable members, this house doesn't form part of, as I said, of the Veteran Housing Project. It can therefore not be alienated or bequeathed. So the veteran, the information that the ministry has is that the veteran already owns a house and that his surviving spouse and family can inherit that house. Thank you.
Thank you.
How did I, you want the question?
No, you are done. let's go for tea, you pick it up after tea.
Just one small question, Honorable Speaker.
Okay.
Very small. No, I thank you, Honorable Minister. I'm not going to ask you the name of the person. I'm going to come to you and just discuss that matter with you personally.
Thank you very much. Tea time.